Good afternoon, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in dockets number 2021-143E and 2021-144E. Before we get started, we'll take roll. Present in the hearing room, we have Commissioners J. Williams, C. Williams, Powers, Belzer, and Thomas. Joining us virtually, we have Commissioners Irvin and Caston. Attorney Cooper.
Thank you, Mr. Chairman. Mr. Chairman, I believe right before we broke for lunch, I had paused with Mr. Morgan, and so I'd like to just pick back up with a couple of questions for Mr. Morgan. It'll be quick, and then I'll go over to Mr. Lawyer if that works for you, Mr. Chairman. Thank you, Mr. Chairman. Mr. Morgan, appreciate your patience in your answering the questions. I just have a couple of questions to go. I asked you earlier about participating in the solar choice tariffs, the company's solar choice tariffs. I understand you did not participate in that docket, but I then asked you about if you were aware if there was an interim tariff in effect now and there was a permanent tariff that will come into effect. And I believe you said yes, but I'm happy to re-ask that question.
Yes.
Okay. So is it your understanding that the interim tariff is in effect now and it started on June 1?
Yes.
And is it your understanding the permanent tariff will not come into effect? It's not available until January 1 of 2022.
Yes, that's my understanding.
Okay. And so are you aware under the interim tariff that's currently in effect that customers under the interim tariff are not subject to TOU rate, time of use rates, sometimes referred to as TOU rates?
Yes.
And are you aware that customers subscribing under the interim tariff are not subject to CPP or critical peak pricing rates?
Yes, I believe so.
And you're aware that the customers subscribing under the interim tariff are not subject to a minimum bill?
Yes.
And you're aware that customers under the interim are not subject to a grid access fee?
Yes.
And just to save time, I have to go back through all of those things, but to save time, Mr. Morgan, you're aware that all of those things I just read to you, TOU rates, CPP rates, minimum bill, and grid access fee, are all features that are features for the permanent tariff that customers after starting January 1 and after, they will take subject to those features.
That is my understanding.
So it's possible that it's reasonable that customers could be signing up now for this interim solar choice tariff because there's no TOU, no CPP, no minimum bill, no grid access fee, and they realize that if they wait till after January 1, all of those features will take effect, correct?
That is a possibility.
Okay. Thank you, Mr. Morgan. Okay, Mr. Lawyer. Mr. Lawyer, I know you're familiar with Act 62 in general. Is that correct?
That's correct.
And Mr. Lawyer, I want to ask you about Section 5841.05, which deals with renewable energy programs. And well, do we have a copy of that we can get? Do we circulate that? I think this was submitted as a cross exhibit, so I'll give a moment for those hard copies to be submitted. And if you'd like for us to email those around, we'll do that, either Sam or Will. Would you like those emailed around as well?
Please share the number with us, sir.
It's Section 5841-05, and it's a cross exhibit we provided in advance. It says Renewable Energy Program Section 1, Title 58 of the 1976 Code.
So does it not have an exhibit number, cross exhibit?
It says DEC DEP cross exhibit number 1.
Okay.
Mr. Lawyer, do you have a copy of this?
No, I don't.
Okay. Here you go.
Thank you, ma'am. All right. Please proceed, sir.
Okay, thank you very much. Mr. Lawyer, I want to read to you the second sentence of this section. The commission is also directed to ensure that the revenue recovery, cost allocation, and rate design of utilities that it regulates are just and reasonable and properly reflect changes in the industry as a whole, the benefits of customer renewable energy, energy efficiency, and demand response, as well as any utility or state-specific impacts unique to South Carolina. Did I read that correctly?
You did read that correctly.
Do you agree with me? That's a pretty broad charge that the legislature's put forward.
I would agree it is very broad.
Thank you. And Mr. Lawyer, are you finished?
Yes.
Thank you. And Mr. Lawyer, I know you were asked a question about the ACEEE letter.
Mm-hmm.
And do you have that letter still in front of you?
I do.
If you look at the first line of the second paragraph of that letter, I'd like to just read to you what it says. It says, and this is from the ACEEE.
Mm-hmm.
It says, programs that integrate energy efficiency, solar and battery storage, combine the benefits these distributed energy resources such as grid stability, resilience, emissions reduction, and energy savings. Did I read that correctly?
You did.
Object, Mr. Chairman. I believe Mr. Cooper may be trying to get in indirectly, but he can't get in indirectly. You know, earlier you denied the request to say CCL to move that letter into the record. Don't believe that Mr. Laura should be asked to testify to what Mr. Cooper's reading.
Mr. Cooper, you have a response?
Mr. Chairman, this letter it's been filed, it's in the record, it's in the public purview. I'd ask that, it's in the docket. I may have said record. It's in the docket. It's been filed publicly. For anybody who wants to go online, they can go and look this up. And so I'd ask that the chairman take judicial notice of this letter.
Yeah, thank you, Mr. Chairman. I don't think that it's proper for the commission to take judicial notice just of any old thing that's been filed on its docket. Yeah, I'll say that.
Mr. Chairman, I don't think that this is any old thing that's been filed in your docket. I mean, we have correspondence that shows that the Director of State Policy, ACEEE, has reached out to Ms. Boyd. I'm submitting an updated comment letter on behalf of the American Council for Energy Efficiency as part of this. We appreciate the opportunity to comment on the Duke Energy Progress, Duke Energy Carolina Smart Saver. Follows up again. Ms. Boyd, I'm reaching to submit the attached letter of support on behalf of the ACEEE. Could you please file them the appropriate proceedings? Please let my colleague Brian know, CC'd, if we need to take additional steps. They put something in a public docket. It's available for everybody to see. This commission is a panel of experts. This commission is capable of evaluating these documents, and I don't understand the concern about putting something in front of this commission.
I tell you what, you're earning your fee today.
Mr. Chairman, if I may respond.
Mr. Chairman, could you repeat that, please?
But listen, Mr. Knowles want to help you out. They're not a party. It is hearsay. We allow almost anything. I think we truly do allow anything on the DMS for the most part. If they wanted to intervene and be a part of this proceeding, they had the opportunity to do so. They did not. So the objection is sustained.
Thank you, Mr. Chairman. I'll move on. All right, Mr. Lawyer, I'd like for you to, I believe you have in front of you, Section 583720, which is the energy efficiency statute. It was also Witness Duff's rebuttal exhibit number 2. I think it's been marked as lawyer cross exhibit. Do you have that?
I have Duff's exhibit in front of me. I don't have a cross exhibit that was given to me.
In the,
They matter.
it doesn't. Just to be clear, what you're looking at is the Duff exhibit is 583720, correct?
That is correct, yes.
Okay. And I'd like to go through that with you. If you see the second sentence that says, if adopted, do you see that?
I do.
Okay. If adopted, these procedures must provide incentives and cost recovery for energy suppliers and distributors who invest in energy supply and end-use technologies that are cost-effective, environmentally acceptable, and reduce energy consumption or demand. Did I read that correctly?
You did read that correctly.
Okay. It uses the terms who invest in energy supply and end-use technologies, correct?
It does.
And that term could be broad enough to refer to energy efficiency, correct?
How so?
Well, couldn't an energy efficiency measure, couldn't that be an energy supply or an end-use technology that is cost-effective?
That is what it says.
Okay. And that could also be the same for a demand-side management or DSM program.
That is correct.
So regardless of whether it's whether you categorize it as DSM or EE, it falls under this statute, correct?
They do, but when we're talking about specifically solar PV as an EE measure, no, I do not agree with that.
And
I don't agree that they're cost effective. Mr. Ori goes into great detail about that.
Oh, I understand, Mr. Lawyer, and I understand you've offered your conclusory statements about this program. I'm just asking you to testify about the meaning of this legislation.
Right.
Just in general, just in broad strokes.
And again, you can't look at this by itself without looking at Act 62.
Well,
Especially when you're talking
let's
about the
go there.
revenue
Let's
recovery
take our
part of it.
time. With all due respect, Mr. Lawyer, let's answer the questions. I understand, and I'm going to let you answer however you want, but I'm asking very specific questions. And so please at least answer my questions as you go forward with your testimony.
Okay.
So for the record, let's go back and say that we agree that this sentence I just read applies to EE or DSM, correct?
Attorney Cooper, give me, I'm sorry to interrupt you. Attorney Knowles, this is your witness, right?
Yes, sir.
Attorney Mustin, could you give Attorney Knowles that chair?
Yes, I'm glad to.
Thank you, sir. All right. Attorney Cooper, if you would, please proceed.
Okay, thank you, Mr. Chairman. I'll ask my question one more time. I think, Mr. Lawyer, we established that the section I just read to you, the sentence I just read to you, applies to programs, qualifying programs. Let's say this, qualifying programs, whether they're EE or DSM,
That have been
correct?
qualified, yes.
Yes, okay, but it can be DSM or EE.
Sure.
Okay. Okay, and it says, allow energy suppliers and distributors to recover costs and obtain a reasonable rate of return on their investment in qualified demand-side management programs sufficient to make such programs at least as financially attractive as construction of new generating facilities. Is that correct?
You read that correct.
So if there's a program, again, just if there's a qualifying program, then there is this idea built in here that there's that net income is recovered, right? That's a qualifying program.
If it's a qualifying
Yeah.
program, what we have in front of us, we take the
I-
position, we maintain that position that it is not.
Okay.
So it would not qualify.
I understand. This is a pretty broad statute for qualifying programs. that as long as it meets any of these contours, I'd say this is not limited in any way. It's talking about if you invest in energy supply and in-use technologies that are cost-effective, environmentally acceptable, reduce energy consumption. These are pretty broad parameters to operate within, correct?
They're very
Objection,
broad.
Mr. Chairman. I just, to the extent that Mr. Cooper is going beyond the plain language of the statute, that's calling for legal opinion.
So, Mr. Chairman, where are we with ORS? Are they going to do this or not do this? I know they don't want us to, but
All right,
where
Mr.
are we?
Cooper, you're starting to touch on the line a little
Yes,
bit.
sir.
Just try to keep it professional and above board.
Yes, sir.
Mr. Laurie was qualified as an expert in energy efficiency, demand-side management, programs and implementation of the programs, and I think he's capable of answering the question. Objection overruled.
I forgot where we were, Mr. Cooper. If you could.
Sorry, Mr. Lawyer, I'll repeat the question for you. It was just that, looking at this sentence again, that, provide incentives, cost recovery for energy suppliers and distributors to invest in energy supply and in-use technology that are cost-effective, environmentally acceptable, and reduce energy consumption or demand. Those are pretty broad parameters within to operate, to evaluate a program.
Yeah, thank you for restating that. Now I remember. Yes, it is very broad. And as I stated to Ms. Mixon earlier when she was questioning me, there's several things in here that we don't agree with.
And so the term cost shift, you would agree that term does not appear in the statute that I just read to you. I understand it's in Act 62, but it does not apply to, cannot be found anywhere in the statute I just read to you, correct?
Without reading it subject to check, I don't believe it does say the actual words cost shift, but I don't see how you can divorce any of this from Act 62, which does specifically address cost shift.
Thank you. Thank you, Mr. Lawyer. Mr. Lawyer, so let's go to this. Did ORS actually evaluate the Smart Saver program as an EE program? I mean, you testified it's not energy efficiency, it's not under this. Let me back up. I don't want to put words in your mouth. Is this a fair characterization of your testimony that earlier today you said this program is not EE and we can take liberties in applying the UCT test or other tests because it's not an EE program? Is that a fair characterization of your testimony earlier?
I think you got it about half right. We looked at it both ways. All
Okay.
right? Let's say this is an EE program. Now let's go through the review process. But then, no, wait a minute, it's not an EE program.
Okay.
We did it both ways.
Okay. Maybe I just misunderstood you. I thought earlier today you were saying that it was not an EE program and therefore.
We did come to that conclusion that it was not an EE program.
Okay. And did you come to that conclusion because you believe that solar is just different? I mean, solar's.
Well, I would agree that it is different.
Okay.
It's an actual generator.
So is it
behind the meter for your own self-consumption? Whatever you don't use, you can export back to the grid and get paid for it.
But the program.
You're not changing any end-use product in your house you're not making anything more efficient. You're just getting your electricity from somewhere else.
And Mr. Lawyer, but you'd agree with me that the Smart Saver program, focusing just on the Smart Saver program, is not examining export of energy back to the utility, correct?
Not that I'm aware of.
Okay. And it's possible that a generator.
Chairman Williams. Chairman Williams.
Yes, sir.
This is Commissioner Caston. Could you ask witness lawyer to speak more directly into the microphone, please, sir?
Yes, sir.
I apologize.
Thank you, Mr. Lawyer. So, Mr. Lawyer, but the point of this is that a generator regardless, if it's a behind-the-meter generator, it does have the potential to reduce energy consumption or demand, doesn't it?
Has that potential.
Okay, thank you.
Sure.
And if it's a solar PV, good chance it's environmentally acceptable, correct?
It's a good chance it is. And like I said earlier, until the end of the life, what do you do with it? How do you dispose of it?
Sure.
Some would argue it's not environmentally friendly.
Okay.
However, as a functioning renewable energy source for a customer, yes.
Thank you, Mr. Lawyer. And I want to turn now, Mr. Lawyer, was it your testimony earlier today, and I'm not trying to put words in your mouth, I just want to make sure I state this correctly. Was it your testimony earlier that the company only looked at the UCT test? Did I have that correct?
I don't believe I said the company only looked at the UCT test. No, I thought I mentioned that they actually provided the TRC results in their application.
Okay, and thank you.
And forgive me if it wasn't their application, it might have been discovery.
Sure. Thank you, Mr. Lawyer. And subject to check, would it surprise you that in its testimony, the company addresses all 4 tests in its file testimony?
I think that was in rebuttal, maybe?
But between direct and rebuttal,
Yep.
they've addressed all 4 tests. And for every test that ORS submitted data requests to the company, it provided its data and analysis, correct?
Did they provide everything we asked for? Is that the question?
Yes, Mr. Lawyer.
Yes, I'm not aware that they did not.
Okay, thank you very much. And then finally, earlier this morning, I again want to make sure I'm accurately capturing this. You mentioned the term rebound effect, and you said there are other terms like rebound effect, and you may have thrown in some more terms, and you said, I don't even know if something like, if that's addressed or that's even known. Does that sound?
Mr. Lawyer, if you could do me a huge favor and take that microphone base and place it on your binder. Thank you, sir. I appreciate it.
Hear me now. All right. Did I mention the rebound effect earlier? Yes, I did.
Okay, and would you mind defining, what does the term rebound effect mean?
Basically, somebody that is a solar customer, you would think that the consumption they use behind the meter would be a one-to-one correlation to reduction in demand or needs from the system. And that's not the case. There's usually the folks that get solar, from the research I did, they actually use more. They consume more electricity. They've got this free source of energy, so they just use more. It's like buying a fuel-efficient car and then driving more because you can.
And, okay, let's unpack that if we can.
Sure.
I understand that the rebound effect relates to the concept of energy efficiency measure that actually ends up someone using more because they have the energy efficiency measure.
It wasn't because of an energy efficiency measure. It was because of solar PV specifically.
So is it your testimony that the rebound effect applies only to solar PV?
No, I didn't say that.
Okay.
When I was speaking of it, I was speaking of it in that context.
Okay. So would you agree with me that the concept of a rebound effect is a concept that could apply to any technology that's anything energy efficiency related?
Yeah, potentially could.
Okay, so it's not just an EE solar PV
To
concept.
the great extent of solar PV, I wouldn't think so.
Okay, so for example, this idea that you mentioned, it could result in someone consuming more. If you had an HVAC EE program, are you aware the companies have a HVAC EE program?
Yes.
So under that program, if I participate and I have an HVAC EE, 2 nights ago, it was 67 degrees, but I might say, well, I've got this HVAC that's EE. I'm going to go ahead and switch my heat on and bump it up to 70 because I'll be more comfortable. Would that be a fair example of a rebound effect? I'm using something more because I have this efficiency measure.
It could be very small.
And there's a process by which the companies, ORS, this commission can evaluate for a rebound effect. Is that correct?
I don't know if this commission has the ability to do that, but
But, well, under
hire
the,
maybe somebody to do that.
sorry, let me unpack this. Sorry, that's a very fair point. It's possible, right, not possible, but it's true that as part of the collaborative, that there is an that there's actual results are reviewed to evaluate a program that's in existence, and one of the parts of that is to evaluate and check for something like rebound effect. Is that right?
I don't know if I've ever heard that term, to be honest with you. But yes, EM&V could probably do something of that nature.
Okay, so the EM&V, is it fair to describe the EM&V as an after the effect true up? It's, after a program's effective, a true up or a review of a program. Is that kind of a way of thinking about the EM&V process?
Yeah, you can look at it like that.
Okay, so it's whether you're talking about spillover or free rider, or whether you're talking about rebound for any number of EE programs, you would take this process that's part of the collaborative that's established, known as the EM&V, which we said is really just a after effective date true up of a program, and you can evaluate all of these concepts for any EE program, correct?
I guess you could, but those are actually qualified EE programs.
But there's a safeguard in place that makes sure they continue to be once you have actual data. I mean, isn't that the important part, is you start getting actual data and you look at these programs and say, are they truly EE programs? So that's a safeguard that's in place.
No, I don't think it says they're actually EE programs. They measure their impacts and benefits. That's it.
So programs that have been adopted by this commission,
Right. They are actually EE programs.
okay? And they are in concepts such as rebound effect, in spillover or free rider. Those programs continue to be evaluated. Those concepts continue to be evaluated once those programs are put into effect, correct?
That is correct.
Okay, so we're using actual data of the programs to come back and measure these programs after they put into effect, correct?
Correct.
And so if this program was put into effect, the Smart Saver program, it would be treated just like any other EE program in the limited extent, in the very limited sense that you would take actual effects of the program and you would come back in the following years and you'd be able to evaluate the impacts of rebound, free rider, spillover, just as you do for any other EE program that's been adopted by this commission.
Well, a couple things. First of all, you have a portfolio of EE programs that have been approved. They have a lot of historical data to back them up and how they work, how they operate. You're going to have very minimal tweaks in those EM&Vs. You're talking about a proposed program now that has been done nowhere, anywhere in the country that I'm aware of, that Duke's even admitted to as well through discovery. You want to take a chance with ratepayers' money from this point down the road and then fix it later for something that we don't even think is an EE program?
Well,
I don't agree with that.
And I understand, I appreciate that. If we could, I think you've got a couple of points there, and let's unpack both of them, if we could. Regardless of whether a program has been implemented in another jurisdiction, if a utility is coming before this commission to seek adoption, it would be the first time such a program would be implemented in South Carolina, and there wouldn't be existing data for that particular utility, for that particular program in South Carolina if they've not sought the approval of the commission, correct?
There's no data that I'm aware of at all.
Okay. So for any new EE program, you're not going to have actual data about the impacts of the program until after the commission adopts that program.
It depends on the program.
Okay. But if it's never been applied.
You've got baseline data on your traditional programs, if you want to call them that have been around for years and years.
But it wouldn't be data
Besides-
from South Carolina for that particular utility if it has not been approved by this commission.
I'll just object, Mr. Cooper. I think Mr. Laura may not have finished his answer.
Oh, I'm sorry. Yeah, I apologize. If that's the case, please finish.
I lost my train of thought already. So
I think we've kind of covered this. The point of it is if a program, regardless of whether it's in another jurisdiction, for a utility to implement a program in South Carolina, it has to first seek approval of this commission, correct?
That is true.
And so for that particular program, it would not have existing data on how that program operates and works in South Carolina for that particular utility, correct?
That would be correct. They're usually modeled after programs in other jurisdictions, though.
Okay, thank you. And so just like for those programs, the current program has not been in use in South Carolina, correct?
The proposed program?
Yeah.
No. Not at all.
And just like those other programs, the proposed program would be subject to a after effective true up that would it would have a process where real data is evaluated, and these concepts could be evaluated and measured, correct?
That is correct. We don't wish to see that happen. We do not think you should be gambling with ratepayers' money.
And I appreciate that. And I guess what I'm wondering is it more of a gamble to not explore a program that offers potential savings to all customers, regardless of whether they participate or not, when you know that program is going to be evaluated after being implemented and is subject to being stopped immediately after implemented? Isn't that more of a gamble, Mr. Lawyer?
No, I don't think that's more of a gamble.
Okay, and so anytime you adopt an EE program, the utilities are coming before this commission to say, we don't have data from South Carolina for our particular utility. So anytime a utility is putting a new program in front of this commission, under your words, the commission would be gambling when they adopt it. Is that correct?
No, I don't think you're getting the full picture of what I'm trying to say. Usually EE programs that are proposed are actually EE programs. They qualify as them just by the very nature of what they're supposed to do and how they're supposed to perform. At that point, yes, if it's an EE program, we will go through the EMEV process and do the true ups accordingly. However, solar PV is not EE. We don't even think it should take that next step. We don't think you should gamble with customers' money to prove it right or wrong.
And so in order to show something is or is not a solar program, in order to show something is or is not an EE program, the whole point of the exercise would be to put data and analysis that follows those things that have been agreed to in the EE DSM collaborative order, the mechanism as it's referred to, and to evaluate those things according to those adopted principles and put that before the commission and have a hearing on the data itself. Isn't that correct?
I'll just object that there's a lot in that question. So I'd ask if Mr. Cooper could break that down.
I'd be happy to. Mr. Lawyer, I guess I'm just troubled by the fact that, well, it doesn't matter what I'm troubled by. Mr. Lawyer, if this commission has to consider whether a program is EE or not, doesn't it first start off with the EE program, the EE legislation statute that I just read and say, okay, well, we've got to measure it against this statute. Isn't that part of the process?
That is part of the process, and as I've expressed already, we disagree with several segments of that
Sure.
statute.
I understand. And
Not
then,
divorce it from this other statute, Act 62.
Right.
They work in conjunction.
and the other part of this is there's an EE mechanism that was filed. It's a settlement between multiple parties that was approved by this commission that has certain agreed to items such as testing, utilization of the UCT test to measure whether a program is an EE program or not. Is that correct?
I don't think the tests are used to determine if it's an EE program. They're used to determine their cost effectiveness.
And
If-
so, sorry, please go.
No, go ahead.
And so we can't just, whether we like a program or not, we can't just say the commission, well, we don't like it, you shouldn't adopt it. We have to look at things like the UCT. We have to look at things like whether it's cost effective, right? That's the whole point of this exercise, correct?
I agree, you should look at all those tests
Okay,
for any program you want to put solar under,
okay.
just not EE program.
So you wouldn't have, so if it's an okay, yeah, I understand you now. Okay, Mr. Lawyer, Mr. Morgan, thank you both very much. I appreciate your time. I appreciate your answers to my questions. I have nothing further, Mr. Chairman.
Thank you.
Thank you, Mr. Cooper.
Commissioner questions? Commissioner,
Chairman Williams, if you have not called on someone else, I have a few questions.
Commissioner questions? Commissioner Powers?
I guess I can ask either one of you then, can I? Mr.
It's
Lawyer,
up to you.
since you got your microphone close now, your testimony very clear that your position that this is not a program, it's prohibited, any cost recovery is prohibited. When I was asking, I don't know which witness of the company earlier, it was said that the public would get this long-term benefit, but nobody could quantify when that benefit would be. Assuming this program were enacted, how long would it be before the public and ratepayers were to see, I'm talking about non-solar ratepayers or the general public, before they would see any benefits from the program?
That's a very good Can you hear me? That's a very good question. I have not done that analysis myself. Maybe Mr. Horry can answer that a little better than I. On a higher level, I can tell you, we had the solar choice dockets. It's my understanding that costs and benefits of solar are already accounted for in there. This is a whole new net metering program. And the costs you speak of that would be disallowed if this were an EE program or the lost revenue piece. The old net metering, Act 236, the companies basically had a pass to get those lost revenues. That's the way it was structured, to jumpstart the market. We've done that. Now we've got to the next phase, solar choice. As your new net metering. All the benefits and costs I thought were accounted for in there. So the benefits should be going forward.
Okay, so Mr. Ori would be the one to ask about what this costs the ratepayers, or?
I think so, maybe.
Okay.
I'm not sure if he's done it that deep of analysis, but yeah, you could
Well,
ask him.
I don't know if on a higher level or not, if this is the question. Do you think if this program were accepted that this would open a Pandora's box for other programs or other attempts at programs? Or do you think the definition is that precise and that clear?
No, I wholeheartedly believe you would open a Pandora's box.
Okay. And do you think this also creates a cost shift?
Absolutely.
Can that be quantified, or would be,
I don't think we've done that in depth of analysis. I know I haven't. I can't speak for Mr. Morgan. Maybe Mr. Ori. I don't know.
and I guess
anytime you add another lump of costs on top of costs that are already there, I can't see how you don't.
okay. Thank you very much.
You're welcome.
Mr. Chairman.
Chairman Williams, go ahead.
Vice Chair Belzer, then Commissioner Caston.
Good afternoon, Mr. Lawyer.
Good
How are you?
afternoon, Commissioner Belcher.
In response to Commissioner Powers, you indicated that you think this type of proposal, if approved, would open a Pandora's box. Can you give any specifics or details?
Sure, I'll give you one thing that's been in the back of my mind. What about community solar? You want to call that a EE program as well? I don't see that or how that would be classified. But I can see that coming down the pipe.
Anything else? That's one. Pandora's box is
No,
big.
we'll stick to the one, but you can see the trajectory, I guess. Be anything.
Assume I can't.
I'm not as creative as some to think of those programs that would not be EE, but we try to be qualified as.
We've had some discussion this morning about with regard to Chapter 37 and 583710. Do you still have a copy of that in front of you?
I heard the second one. What was the first one, Commissioner?
583720. It's a statute. I think y'all had, one of you had it.
583720, yes.
Yes, sir.
I thought
And
you said another one as well.
I think I misstated. Thank
Okay.
you for that. And there's been some discussion of the last sentence of that statute where it says the term demand side activity. Are you with me there? Means. The last sentence of the statute. For purposes of this section only, the term demand side activity means a program conducted by an electrical utility. I'm gonna
Yes,
leave it.
I see where you are.
Okay. Including but not limited to utility transmission and distribution system efficiency, customer conservation and efficiency, load management, cogeneration, and renewable energy technologies. Would ORS's position change at all if instead of this program being characterized as an EE program, that it would be characterized as a DSM program?
It's a good question, Commissioner. Here's what I think about demand side management. It's something that can be controlled, something that can be used for load management or something along those lines. I don't see with the technology today how that's doable.
Can you expand on that for me a little bit? What do you mean with the technology today, it's not doable?
Well, you take a solar system and you put it on your house, and it's either generating or for your consumption or it's exporting back to the grid. There's no controlling it.
Okay.
It does what it does on its own. You have no control. The company has no control. I don't see any kind of management involved with that.
Okay. Let's take, just clear your mind of the solar choice statutes and docket, okay? Just forget that for a second, if you would. And with the answer that you just gave me, because solar only generates when the sun is shining, not when it's cloudy, not when it's rainy, not when it's dark. Does the technology and how it generates only when the sun is shining, does that impact either DSM or EE in ORS's analysis?
For DSM, I think if it was controllable, maybe.
Okay.
I don't know. I'd need some more details behind it, but on the surface, that sounds more reasonable to me.
Okay. Thank you. I think that's
You're
all I got right now, but I may be back. Good afternoon, Mr. Morgan.
Good afternoon.
I would like you to turn with me to your testimony on page 6, rebuttal, page 6. And this is kind of just a clarification, if you would. And I'm at the last question that's on page 18, and I'm specifically looking to the order number reference on lines 19 and 22, and you reference order 2156. Would you agree that that is actually order 2021-569? Can you check on that for me? I think that is just a correction that may need to be made, if you wouldn't mind checking and letting us know. Also,
I will check.
yeah, on your with regard to your exhibits, I'm looking at exhibit OOM2, page 2 of 6. And it's actually on page 3 of 6 as well, but probably more. Am I correct that this EE program that the Duke Companies is proposing, that it's a residential offering if approved?
Yes, it is.
Okay. Why are you having a non-residential smart saver as an exhibit instead of the residential smart saver?
Can you point me again to?
Well,
the
I'm looking
exhibit?
at your exhibit OOM2. And just look at the title on page 2 of 6. It's a non-residential smart saver energy efficiency products and assessment program. And I believe Duke also had an offering that was a residential energy efficiency program. So my question is, why are we comparing to the non-residential and not the residential? Or not, it's not really a comparison, but why is this reflected? Mr. Lawyer, you look like you're ready to jump in to answer.
I was just gonna help out.
I think I need to. I'm looking. Is that from my direct
No, sir,
testimony?
your sir rebuttal.
Oh.
I
Okay.
apologize. I thought I may not have said that.
Okay. I think I remember what my exhibit is. I don't see it right now, but what I was pointing out was to the fact that the company, in their description of that program, did mention that renewables were not considered as energy efficiency.
Okay, do you know if that same qualifying language is in the residential smart saver?
No, they did not make that determination. So that's why I'm wondering why they.
Okay, let me stop you right there. I'm sorry to interrupt. Not in what is being proposed now. I'm talking about in the current residential smart, the comparable, okay, you've pulled out one tariff,
Mhm.
okay, and it's non-residential. Isn't there a current, excuse me, this is non-residential. Isn't there a current residential tariff similar to this non-residential that you've listed?
No, I did not check on the residential. I saw this tariff with their explanation saying that the renewables side or what was listed, they do not consider that as energy efficiency.
Okay, thank you.
Yeah.
And I also noticed that this was effective for service on or after March 14th, 2018. Do you know if this is the latest iteration of this tariff, or is there one that has come down since then?
I'm not aware of a newer version.
Okay, thank you.
Commissioner, may I add to that?
I'm not, yes, sir, Mr.
I think
Lawyer.
the whole point is, I don't remember if it was in the residential or not. It really doesn't matter if it's a residential program or not. This is how the company defines electric generation from either non-renewable or renewable is not considered an EE measure. I don't see how that could apply to one tariff and not all of them. As a matter of fact, it even goes further in this program to reference high efficiency HVAC. They draw the distinction in their testimony. I believe it was Ms. Ford maybe, or Mr. Duff, that solar PV is just like high efficiency HVAC. Well, how can that be when you're saying the opposite on the same tariff?
Well, can you say whether or not this is the latest iteration of that tariff?
I believe it is, subject to
Okay.
check. I do believe it is.
Okay, thank you. Mr. Morgan, I'm now looking at your direct testimony in your exhibits. I think that's where it was. On pages, I'm in OOM2. Page 2 of 5 and 4 of 5, and I think the questions and the responses are the same. One's just going to DAC and one's going to DAP. And the request is, will the company seek to recover portfolio performance incentives, program return incentives, and net loss revenues related to the proposed program? And would you read the response that the company gave there, please?
The company will seek to recover portfolio performance incentives, program return incentives, and net loss revenues relating to the proposed program in accordance with the revised mechanism which is effective January the 1st, 2022. The projected impact to the rider for each vintage year is in the attached spreadsheet.
And is that where you derived the numbers that you put in the tables in your testimony?
Yes,
From those?
from that
Okay.
spreadsheet that was provided.
And when the company in that response references the revised mechanism, what is that?
The current mechanism was a revision of a previous mechanism.
The revised mechanism is this application, is that correct?
The revised mechanism is the mechanism that allows the company to recover all these
Is that
costs.
is that the settlement agreement that was in, I forgot the order number?
2021-32, 2021-30.
Yes, that's the revised mechanism?
Yes.
Okay. Thank you very much, Mr. Chairman. Those are all my questions.
Commissioner Caston.
Good afternoon. Can you hear me okay?
Yes, we can.
Lima Charlie.
Good afternoon, then Mr. Lawyer and Mr. Morgan.
Good afternoon.
I can see me, I can't see you guys. Let me see if I can change that. Can you hear me? Okay. Can you hear me still?
Yes, I can.
Yes, sir. We can hear you.
Change the layout. Okay, I want to change my layout so I can see Mr. Lawyer. I really don't want to look at me, but I'm looking at me right now. But let me go ahead and ask the questions anyway. But you can hear me, correct?
Yes, sir.
Yes.
Okay. Do you agree with witness Morgan's and witness Ory's use of the EIA, which I think is the U.S. Energy Information Administration, I believe that is? Do you agree with the use of EIA's definition of energy efficiency?
Was that to
Mr.
me?
Lawyer.
Yes, I do.
Yes.
Yes.
In multiple hearings, I've heard this entity referenced and regarded as an authoritative source such as this. Do you agree with that? As far as EIA being an authoritative source on energy information, items such as energy efficiency.
I do.
In testimony, I think last week, I'm pretty sure this is the case, relative to the BYOT, the meter, the thermostat. As I recall, the question was asked, I think of Mr. Duff and perhaps others, is is this thermostat an energy efficiency device, or is it a demand side management device? The question was asked, I think, along those lines, and what does it do energy efficiently? I believe I heard you respond to Attorney Cooper or someone that you agreed it was an energy efficiency device. Tell me exactly how this thermostat is an energy efficiency device relative to the definition EIA has given.
Well,
Are you saying that that thermostat is an energy efficiency device or simply a demand side management device?
well, that's a good question, Commissioner. Thank you. Let's back up just a second because I think you referenced something you heard last week from company
In
witness
the
Duff.
testimony last Thursday.
Okay, and I think he made two distinctions, if I'm not mistaken, between the two different thermostats. There's a smart thermostat, and then there was the BYOT.
Right.
They can actually come in, and like I said earlier when I was explaining demand side management, you can actually come in and control the thermostat. I don't think that capability is available on just a regular smart thermostat, if you will, that knows your patterns or knows it can turn itself up or down whenever you're not home, or it can be controlled remotely to control. So I think that's the difference that Mr. Duff was trying to make, if I remember correctly, and I agreed with what he was saying last week. 1 foot it can be,
So
and
to
the
make
other
sure I
foot it can be DSM.
understand. Okay, so to make sure I understand, the thermostat BYOT that we're talking about, it's part of this program, is a DSM device?
That's the way I look at it, yes. You could hook up to the thermostat and control the HVAC unit. You're managing it. You're curbing load if you need to, whenever there's stress on the system, or you need free up some for reliability purposes, whatever the case may be. You can come in and control it.
Okay, that was my understanding, I think, from Mr. Duff when asked those questions, and that in the wintertime, they have the ability to turn my thermostat down if they
Correct.
need to reduce peaking, and in the summer, they have the ability to turn it up. But as far as an efficiency device, it does not function as an efficiency device. And I think I recall that being the case, that no, it does not. It is a DSM device. That's your understanding, correct?
Yes, sir.
Okay. During the break, I had an opportunity to read the ACEEE letter. Have you had a chance to read that?
No, I have not read it today. I've read it before when it was first filed.
Commissioner Caston,
Yes.
that letter was offered into evidence by a party. It was objected to. The objection was sustained. Respectfully, I ask that you not reference the letter.
Oh, I apologize. I stand corrected, and I will not. Which will actually save us both time. Does rooftop solar reduce consumption?
I think it has that potential, Commissioner. I don't think that's true in every single case, no.
So does it reduce the rooftop solar on an individual residential house? Does it reduce the consumption of the electrical use of the homeowner? rooftop solar. I
Yeah.
put rooftop solar panels on my house. Does it reduce my consumption of electricity?
Not necessarily, no. It can, it has that potential. Depends on the individual consumer and their behaviors.
Okay. If this program is approved, would the participating customer become a customer generator or something else?
I think if they get the solar PV system, they're always a customer generator. Whether they're in a solar choice program or another program that may be proposed. But they're still a generator, they still generate electricity.
In this program, would these solar panels be controlled in any way by the company to allow it to function as DSM?
No, no, sir.
I'm going to ask what I think you've already answered. You believe that solar panels in and of themselves is an energy efficiency device?
No, I do not.
What is it?
It is a customer generator. It is generation for that customer to use behind the meter as they see fit. It does not make any end-use appliance in that house any more energy efficient than me sticking a diesel generator behind the meter.
Okay. So relative to Commissioner Powers and Belson's questions, or I guess on the Pandora box question, and you gave Vice Chair Belson, I think, an example. But I was trying to understand that. Are you implying that classifying PV solar panel as EE, is that what you're saying would potentially open a Pandora's box? For what? Unintended consequences of classifying it as EE? I mean, is that what you're implying? Because I wasn't real sure.
What I was trying to say, and maybe I said it incorrectly, and I apologize. If you want to classify solar PV as EE, as an EE measure, yes, there could be potentially other programs coming down the pike involving solar PV as EE. And I gave her an example of community solar. Well, it's just a bigger system. It's not on your house, but I could see maybe somebody wanting to make that an EE program as well. How, I don't know. I don't have any details on it, but just kind of spitballing with you that I could see something happening along those lines.
All right. What is distinctly different about this proposed program and solar choice that exists currently?
Well, Solar Choice is a net metering program.
Mhm.
And Mr. Cooper was right in how he portrayed it earlier. You're on interim riders until the end of this year, and then the permanent riders take effect with time of use rates, critical peak pricing, monthly netting, et cetera, et cetera. This program is an EE program. And the way I see it, it was kind of an end around from Act 236 to then going through Solar Choice and now making it an EE program, trying to claim benefits that are already accounted for in Solar Choice. And it's a way to now capture those lost revenues that are going to be lost when somebody puts a generator on their house. The companies are in business to make money by selling energy. They're gonna sell much less when somebody puts solar on their home. So if now we wanna call it an EE program just to get those, or possibly double counting those benefits, I'm not even sure. Number two, collecting those lost revenues that are now lost from Act 236 getting shut down. And then on top of that, getting an incentive for the benefits that have already inherently been there because the customer participation's already there. Duke is not needed to entice folks to get solar at this point. It's a way to get those lost revenues and the incentive now that you could not get from Act 236 anymore because solar choice was implemented.
Okay. So, Mr. Morgan, if I might ask you actually some of the same questions, if I may.
Yes, you may.
I guess based on your background, engineering and your understanding in that respect, does rooftop solar reduce electricity consumption?
It reduces electricity consumption for the homeowner. That reduction in electricity consumption from depending on the utility to provide that needed electricity, the rooftop solar will reduce that dependence from the utility grid.
Okay, so you're saying any electricity that the solar panel produces and that the customer uses will not be used on the utility, it'll be supplied by the home generation, the self-generation, correct?
Yes, a portion of their dependence on the electricity will be supplied by their PV solar system.
Okay, but I thought I understood, I think you earlier say that, and maybe you referred to studies, and I don't know what those studies were, that rooftop solar in itself did not necessarily reduce the electrical usage or consumption that the individual homeowner uses. Did I misunderstand that?
Yes, what I'm saying, if the homeowner requires X amount of electricity and they are getting that electricity, that X amount electricity from their solar system, then they are not dependent on the utility to provide that energy, but they are using the same amount of electricity to carry out their functions in their home.
So, do you consider rooftop solar or solar panels energy efficiency items?
No, they are energy generators. It's an energy generator device, not an energy efficiency device. They do not reduce any consumption of any end-use equipment within a residential home.
Do you consider the BYOT, the thermostats in this particular program, to be energy efficiency devices or demand side management devices?
That's demand side management in terms of demand reduction device.
That's all I have right now, Mr. Morgan, Mr. Lawyer. Thank you, Chairman Williams.
Thank you.
Yes, sir. Commissioner Thomas.
Thank you, Mr. Chairman. Can everyone hear me?
Yes, we can.
Very good. Thank you. It's good to have you here in person today. Good to see you. Good to meet you. Just looking at a couple of things here. The cross exhibit number 1 handed out by the Duke companies that has section 5827.845A1. The General Assembly finds that there is a critical need to protect customers from rising utility costs. So my question is, does this program have the potential to protect customers from rising utility costs, or does it have the potential to actually increase utility costs for customers? Any thoughts on that, Mr. Morgan?
Well, to my understanding, there's an additional cost that will be laid up on the existing rider as a result of these programs. I guess it's yet to see the reduction, we're yet to see the reduction in customer costs as a result of these programs.
Okay, thank you. How about you, Mr. Lawyer? Do you think that it has potential to increase utility costs for customers?
I do. I agree with what Mr. Morgan just said.
Okay, thank you. And reading a little bit further down, again, this is section 5827.845, subsection C. Almost towards the end of the sentence there, it says that no one class of customers are unduly burdening another. Do you think that this program has a chance that it would be unduly burdening another class of customers?
That would be my understanding, since the recent Solar Choice found that balance to be fair and just. So now adding another set of costs, you're removing that balance that was found.
Okay. What do you have anything to add to that, Mr. Lawyer?
Only that I don't think that there's a chance that it will. It absolutely will.
Okay, thank you. Let me ask you a question, Mr. Lawyer. You mentioned a Georgia Tech study, new recent study. I think you said it was Georgia Tech that indicated that installing solar panels sometimes has the exact opposite effect of instead of causing less energy usage for the person that installs those, that it has the potential to increase energy usage for the person that installed that. Did I understand that correctly?
You understood that correctly. It was a Georgia Tech study. I believe it came out, it was the beginning of last month.
Okay.
If I'm not mistaken.
And so I guess that just relates to just kind of thinking about it from my own personal perspective. If I buy an unlimited data plan, then I know me personally, then I tend to probably use more data. Do you think it's kind of a similar concept to that?
It's exactly the same concept.
Okay. And so I guess, do you think that this study would be something that would be interesting or worthwhile for us to see? Is this something that could be entered as a late filed exhibit, or I guess this is more of a question for the attorneys, the chairman or whatever?
I know the study was loosely referenced. I don't know if it was cited in pre-filed. Attorney Muschin, you're in the producer's line of sight. Fine. I know the study was referenced loosely, but I don't know if it was cited. Is there an objection to it being included as a late filed exhibit? I don't know. I mean, attorneys?
Mr. Chairman, this is Ashley Cooper on behalf of the companies. I assume this was directed to me first. I would say that, we've not had the ability to analyze this report, to ask questions about this report, rebut this report, and so it would be prejudicial to us to allow this in at this time.
Commissioner Thomas, with all due respect, I would have to agree. I think during the interaction, the witness and the attorneys were in the heat of battle, if you will, and I'm sure Attorney Cooper probably would have objected to the mentioning of the study, but based on the objection now, I would deny the request for a late file exhibit on the Georgia Tech study.
Okay, thank you. Just wanted to check and see. I think that's all I have for right now. Thank you.
Thank you, sir. Commissioner Williams.
Thank you, Chairman Williams. Good afternoon. Good to see you all in person. Agree,
You as well.
as
Good
just said.
Afternoon, Commissioner.
I'm going to ask both of you, and whoever answers first is great, and you can chime in as we go. When you think of energy efficiency, I know you've been asked this over and over again, but this is a specific element that I don't think I've heard anything on, and that is, does it relate to the units, the buildings, or the system, the utility system? Do you want me to ask that a different way? Does the question make sense?
Well, I can go off the long-standing interpretation, definition, and what folks that have been in the industry for a long time, what energy efficiency is. You are finding a way to do the same amount of work using less energy and receiving the same output. That's energy efficiency. I think an example was provided to us last week where an electric bulb comparing an incandescent with a LED, you're getting the same amount of lumens light output, but you're using less electricity to do so. That's the long-standing definition that I know of what energy efficiency is.
And I appreciate that answer. I'm going to try to ask my question a little bit differently so to see if there's a different answer. When you talk about that efficiency, is it for the entirety of Duke Energy? Is it for the building that we're in? Is it for the unit that you're a part of?
It's for the building you're in and the company, the utility, they get credit, or they get the benefit of not trying to supply all that energy to the building.
Okay. And you all have spent a lot of time talking about the Smart Saver solar program from a statutorial perspective, and that's incredibly important. But I want to give you a chance for a minute to just divorce ourselves of that and just say from the idea of partnering solar with the bring your own thermostat, if there were no laws involved, does it make sense from a demand side management perspective? Question.
Well, if it makes sense, I'm trying to answer the question in a way where let me go back. It's solar customers who PV customer generators, they can participate in the existing BYOT program. So it's not, I don't think there's anything there that bars a solar PV customer generator than participating in the program. I cannot speak for the company, but I don't know if the marriage that they're doing is trying to increase participation from for the BYOT program, but it's not something that I see is a necessity to put them together, because nothing bars solar PV customer generators from participating in the BYOT program as it exists today, not that I'm aware of.
So tell me if I heard you correctly. The programs exist as they are right now, and there's nothing exponential that gets added by putting them together.
That's my understanding.
Okay. I saw the nod.
I do agree with him. Yes.
Okay. Thank you very much to both of you.
Thank you.
No further questions.
A couple of questions before we take an afternoon break from me. And this is to both witnesses. Witness lawyer, I think I heard you reference that what the company is proposing is an end around to Act 62. Is that a fair description of some of your testimony?
I did say that, yes.
Okay. So, and let's assume that's true. As long as it's within compliance with the law, what difference does it make if it's an end around?
Well, I don't think it's in compliance with the law. Don't think it's an EE program to begin with.
Okay. And so I understand the definition that you asserted. I think it's the EIA definition.
That's right.
But I want to ask you to take the limits off of that definition for a second, and consider this. Could there not be some level of energy efficiency added to the system if there were more users who adopted, or more customers that adopted this program? They added solar panels to their house in addition to the DSM thermostat. Would that not reduce the requirement of the company to provide energy for those customers?
I think I said that earlier. Yes, it has that potential.
Okay.
It's not going to be the same for everybody.
Right. And would that not add benefit to the system?
It could.
It could. Okay. And so would that not be some level of efficiency there? I mean, we don't know what, I'm not asking you to state the amount or how much, but in terms of just talking about efficiency from the company having to produce electricity to meet those customers' need, would that not increase the company's?
It may or may not. Like I said, that potential does exist. I don't know for sure.
Okay. So, but you don't think that potential is worth exploring?
I never said it wasn't worth exploring.
Okay.
It's just not an EE program to do that exploring. If the company wants to propose something else, we're more than happy to look at it. The way this is proposed, we don't agree with it and don't see it as an EE program.
Okay. And so when you say it's not an EE program, are you considering the two components together, the solar, excuse me, the addition of rooftop solar coupled with the bring your own thermostat program? Are you seeing the program as a whole, or are you separating them into component parts?
No, they're two separate programs. The BYOT program is already approved. It's already, we didn't have any issues with it, had our blessing. It's already approved and done. This is a totally separate program, but you have to participate in that one if you want to participate in this one.
Right. So that's where I'm struggling, because you all have provided very clear testimony or position, but it seems, and maybe I'm not understanding the company's position, but to me it seems like this Smart Solar Saver 3S program, it seems to be separate and distinct from the two other programs because of the requirements for you to have both.
You have to be a participant in Solar Choice, and you have to be a participant in the Winter BYOT.
Right. So you have to participate in both. Why are you separating the two programs? Why don't you consider them as a whole? And what if any impact they have on the system by way of efficiency or reducing consumption, conservation, whatever the benefits may be? Can you not see them as a whole, as
I can
opposed
see
to
them working in concert with each other.
Okay.
But they are separate programs. One is a DSM program, one is not an EE program. And you can't divorce, I know you don't want me to go back into the statutory realm here, but, I'm sorry, that was you. but you can't avoid it. And the mechanism set up to recover the cost that would be incurred under the proposed program, we don't find permissible.
based on 58-40-20?
Aye.
Aye.
Yes,
Right.
that's correct.
So the position is just simply Act 236 allowed for certain costs to be recovered under or through solar programs. Act 62 prohibited those costs from being recovered. You have a solar choice tariff, and it's just that simple. This solar component of this program is identical to the solar choice tariff. The bring your own thermostat is already in existence, so it's a no-go from the start.
Right, solar is not an EE measure. The lost revenue aspect is there as well. I mean, there's several. Additional incentives aren't necessary. I think it goes against all the work that all the parties did, this commission did, in setting that solar choice tariff, in cutting those cost shifts to the greatest extent practicable. I don't know why I would want to unwind that and go down this road calling solar an EE.
Right. Well, it's interesting. If that is what they are doing, it's wasting a lot of time and money if that is indeed what they're doing. But I'm not sure about that. Let me ask you this. Morgan Cross Exhibit number 2 and Morgan Cross Exhibit number 3, the minutes from the collaborative meetings, the position that you're taking now, were those positions shared in those meetings?
Let me caveat that for you. I did not attend these meetings personally. Mr. Morgan did, and another colleague of mine in the office. However, I did review the minutes post-meeting, if you will. And as I stated earlier, look, this collaborative, I mean, it's great. Get together, share ideas, bandy about some perspective programs possibly, have the ability to ask questions. However, like I said earlier, we do not get involved in developing these programs, designing these programs, and then have to jump to the other side of the table and actually regulate them. And there's good reasons for that. You've heard the term, the devil's in the details. We didn't have all those details. I can give you a prime example just from reading this one here in November where it says,
What page are you reading?
I'm sorry, this is page 5 of 6 of cross number 2. Where the highlighted part, starting with Forrest Bradley Wright. And in that question, it's asked, can the incentive be used to price out the system? And LH responds, and I'm assuming that's Lon Huber, but I'm not sure just because his name is attached here. Said yes, approximately $2,000 per residential customer on average. Well, that doesn't jive with the discovery request response that we received, and it's notated in Mr. Horry's testimony. That number was now $3,500. So that detail was different. Why would we go through the discovery process and all that during the collaborative when we don't have anything concrete or definite proposed to us at that time? That'd be a waste of time and effort. Let's see what you finally propose, which is what once we got it, it was filed in April. Things had changed. It was $3,500 at that point, or it was $2,000 in this collaborative. That's the point I was trying to make earlier.
I got you. I just and you're exactly right. I'm just trying to understand how all this works. From my perspective, considering how firm your position is, I would question why the program would be presented as it's presented in this hearing if the parties knew that there was such strong opposition from the Office of Regulatory Staff. That's the point I'm making. If they knew that, if they knew, say, hey, we think this is an end around to Act 62. This is not EE. We think you're trying to use smoke and mirrors to get to a certain end result. I just wonder if we would be here today if those thoughts were shared. That's all I was getting at.
Yeah, and I see your point on that. I really do. Even in the January one, there was questions about it being E as well.
Yes, sir.
But it just wasn't from us. So sometimes we don't need to ask the question. Somebody else did.
Understood. If there are no more commissioner questions, we're going to take even if there are, we're going to take an afternoon break. We'll be back at 3:15. Good afternoon, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in dockets number 2021-143E and 2021-144E. Present in the hearing room, we have Commissioners J. Williams, C. Williams, Powers, Belzer, Thomas, and joining us virtually, we have Commissioners Irvin and Caston. We recessed for our afternoon break, and now we're back with commissioner questions. Any more commissioner questions for this witness panel?
Chairman Williams.
I believe that's Commissioner Irvin.
Yes, sir.
Commissioner Irvin, you have the floor, sir.
Thank you. Mr. Lawyer, I'd like to start out with a few questions for you, please, sir. Can you hear me okay?
I can hear you fine, Commissioner.
Thank you. It seems a bit strange to me that ORS takes the position that you will attend these stakeholder meetings, but yet you say that, I believe the words you said were, since we're going to ultimately have to regulate the programs, we don't make any suggested changes or ask any questions. Is that a fair summary of what you told us?
No, that's not what I said, Commissioner. What I said is we don't help in designing or developing programs. We can ask questions at will if we wish.
Okay. Well, that brings me to my next question. Did your staff ask questions at these stakeholder meetings?
I'll defer that to Mr. Morgan, who actually attended the meetings.
Yeah, Mr. Morgan, I believe you were in attendance.
Yes.
Did you ask any questions at the stakeholder meetings?
No, I did not on this subject.
And why is that?
I did not feel it was necessary at that time. Other attendees asked questions, but I needed to fully understand the legality to what was proposed, and before I started to go down a path that would not be appropriate for ORS.
Understand. But ORS is tasked with protecting the public interest. Isn't that true?
Yes, we are.
And so I can understand why perhaps at the first or second, or maybe even the third meeting, you wanted to learn more and kind of see where it was going. But as the process progressed, meeting after meeting after meeting, did you not think that it would be helpful to raise your concerns at that time so that if tweaks need to be made or additional data needed to be provided, or questions needed to be answered, they could have been answered during that process, could they not?
Well, first, when you say meeting after meeting, the first was November 2020, and then January. And since I was of the understanding that an official application would give us a chance to make comments or render our findings, I did not do so in those meetings.
All right. Well, how about once the application was filed by the new companies? Did you use that as an opportunity to review the text of the application and ask questions then?
Yes, we did so during discovery.
Okay. And I believe you, in your testimony, though, you focus solely on the cost of the program that's been presented by Duke. You never mentioned the benefits. I'm just curious, wouldn't a fair look at a new program require the balancing of cost versus benefits before you can take a position on whether or not it's in the public interest?
Well, my belief was the benefits speak for itself, and the company was focusing on the benefits. So I wanted to present the costs for these programs that will be borne by the South Carolina residents.
Okay, But in fairness to all the South Carolina ratepayers, they have a right to know what the ratio is between cost and benefits, don't they?
Yes, they they have a right to know, and they will see the benefits that the company presents.
Commissioner
Well, you
Irvin,
just, I'm sorry,
I'm sorry, may I add to that? This is Robert, lawyer.
I'm questioning, Mr. Morgan right now. Thank you, though. Come back to you in a minute. Here's the other concern that I have, and that is the long-term benefits for any demand-side management program are to reduce winter peak, because Duke companies in South Carolina are winter peak companies. Isn't that true?
Well, that's my understanding.
That's right. And so if Duke Energy Carolinas and Duke Energy Progress can reduce the winter peak, that benefits all customers, doesn't it?
Yes, it would.
And the reason it would is because without those reductions, with this demand side management program that Duke has proposed, their only choice is to go out and build new facilities, most likely gas combustion plants. And the ratepayers would have to pay for those plants, not only the construction, but the maintenance, the interconnection to the grid, and the transmission of that power. All those costs would fall on ratepayers. Isn't that true?
I want to say there are other factors that the company have to consider in order to build a new generation. I think putting this solely on this program, that without this program, the company will have to go and build new generation plant.
Well, I think you make a good point, and that is there is no silver bullet to reducing peak demand. It has to be a combination of programs. Energy efficiency is one way. Demand side management is another. Renewables and storage would be yet another. Would you agree?
Yes, I would agree to that.
Right. And so, to the extent that Duke is trying to reduce their winter peak demand, this program would fit into the definitional category as a demand side management program, correct?
Possibly, but again, it reduces summer peak demand as well.
It does. That's right. I was going to bring that up next. And even though they're a winter peaking utility, it would also help in the summer peak reductions, would it not?
Yes, it would, but
That's
not
right.
not under the umbrella of energy efficiency measure.
I'm not calling it energy efficiency. I'm calling it demand side management because that's what it is, correct?
Well, it is being proposed as an energy efficiency measure.
Well, the fact is that you all were concerned when you saw the word solar, and you immediately jumped to the conclusion there's going to be some kind of cost shift to non-participants. Isn't that the fact of the matter here? Isn't that what we're dealing with? You just jumped to the conclusion that if this program's implemented, we're just convinced beyond any doubt there's going to be a cost shift to non-participant ratepayers.
I'm sorry,
Mr.
Mr.
Chairman.
Commissioner, I cannot agree with that statement that we jumped to the conclusion.
Mr. Morgan, I'm sorry, Mr. Morgan, your lawyer wants to say something.
Mr. Chairman, I hesitate tremendously to rise to object to a commissioner question. However, I believe the tone and tenor of that question was badgering the witness and asking for a conclusion that is inappropriate, and I would object on that basis.
Mr. Chairman, I'm not badgering the witness. I'm asking legitimate questions about his testimony and the record before us. And if I did in any way badger you, sir, I apologize. Didn't intend to do that. I'm trying to get at the truth of the matter and figure out why we're here today and what needs to be determined. That's the only purpose for my questions.
Understood. Attorney Mushton, I think badgering is pretty strong. I don't think Commissioner Irvin has gone that far. I don't think he will. And so, Mr. Morgan, if you can answer the question, just answer them. And Commissioner Irvin, I think sometimes there's a bit of a delay between asking a question virtually and hearing the answer live. So if you would just pause to allow Mr. Morgan to answer the question once you ask your question, sir.
Thank you, Mr. Chairman.
Yes, sir.
Yes.
So, go ahead and complete your answer, if you will.
Yes. First, I accept your apology. But seeing that we jump to the conclusion, it's not how I would state that. We go through a series of process in making our evaluation. Step one, is this truly a EE measure? And step two, does the law allows this type of measure to be under the current program? Step three, what are the costs for implementing and how will they affect the South Carolina residents? And what are the benefits of these programs? So it's a series of things we undertake and try to get a good grasp of the program before we make our determination.
All right. No, thank you, sir. I appreciate your answer, and I'm going to ask a couple of questions for Mr. Lawyer here. Mr. Lawyer, you referenced a Georgia Tech study that looked at how solar adoption could somehow result in a solar rebound effect. And I wanted to ask you, do you have a copy of that study with you?
I do not have the whole study with me now.
Okay. Do you have
Mr. Chairman?
summary?
Attorney Cooper.
I'm sorry, and again, I hate to interrupt. I just wanted to clarify that this is getting into a line of questions about a study that we agreed was not admissible. It was not in the record. And just, I hate to interrupt Commissioner Irvin, but just since he's virtual, I just wanted to bring this up now to avoid any confusion.
All right, and this is the Georgia Tech study.
Mr. Chairman, that's my understanding.
All right. Commissioner Irvin, are you referencing the Georgia Tech study that Mr. Lawyer brought up in his, I don't know if it was cross-examination or direct? I think it was cross-examination.
Yes, sir. I think that since he brought it up, I have the right to ask him about the results of the study. I understand it's not in evidence, but I think it supports the application. And I'm not sure that Mr. Lawyer understands that this was not a conclusive finding as to a rebound effect. The study says it may result in a rebound effect of 28.5% of all solar customers, which is certainly not a majority. It's closer to a fourth of the solar customers. So I just wanted to ask Mr. Lawyer if he was aware of that, if I may.
And I have to be honest with you, without having the court reporter going back to read what he said about the study, I would ask that you limit your questions to whatever he stated about the study.
Yes, sir. Mr. Lawyer, you recall telling us about the Georgia Tech study and how it found that customers using solar panels result in a rebound effect. You recall your testimony about that?
Yes, I did. I did say that.
Would it surprise you to know that the study author says that only 28.5% of solar customers may have a rebound effect? Did you know that?
No, I didn't. I thought it said a third of customers, and the 28% was the difference between what you actually thought the reduction, or based on your consumption behind the meter and the reduction to the grid would be. It's not one-to-one, in other words. There's a 28% gap there. As far as
did you know, excuse me, I apologize for interrupting you. Did you finish your?
As far as the customers that do, are part of that rebound effect, was a third of all customers that they sampled.
Well, 28.5% is not a third, is it?
No.
That's right.
No, not quite.
Did you? As part of the findings.
Commissioner Irvin, I think you were muted during the first part of your question. If you could repeat your question, sir.
All right. Are you aware that this study that you referenced from Georgia Tech has limitations that are part of the conclusion, which say that because of those limitations, the study has limited application, and there needs to be further research. Are you aware of that?
I'm not sure what limitations you're speaking of, Commissioner, but I would wholeheartedly agree that more study needs to be done. It's all the more reason not to approve this program as proposed at this time.
Well, if we adopt the program, we'll see some results in about a year or less. Wouldn't that be one way to evaluate its effectiveness, to have a review of the inputs once it goes into effect?
Now, as I stated earlier, we don't agree with that. We're not here to gamble with customers' money, take a chance on a program that never has been done anywhere else. If you want to do more studies, propose different programs, we're all for that.
But your office doesn't want to be a part of that planning process.
Which planning process are you speaking of? What would be planning?
My understanding is that you've taken the position that because you may have some kind of regulatory role that you can't even participate in the planning of any new program. Is that my understanding of your testimony, your position?
That is my position, and ORS's position. We cannot sit on both sides of the table, Commissioner. In one hand, develop, design, and recommend programs, and then on the other hand, come back and regulate them and say, oh, no, you did this wrong. Guess what? That's a conflict of interest right there.
So we have to wait to the end to find out what your position is going to be. We have to wait till the final hearing.
In some cases, maybe. Not all. Depends on the situation.
And you think that's in the best interest of the ratepayers to do that?
Well, whatever comes out of the planning process you speak of will be fully vetted by us. That's where we step in to take care of looking out for the ratepayer. Propose something, we'll look at it, we'll analyze it, we'll review it, and we'll make our recommendations, just like we are in this case.
Thank you, sir. No further questions.
Thank you.
All right. If there are no more questions for the panel by commissioners, is there any redirect? Yes, sir. Go right ahead.
Thank you, Mr. Chairman. ORS would have a request of the chair based on Commissioner Irvin's line of question. We would respectfully ask the chair to ask Commissioner Irvin to state for the record whether he has reviewed material outside of the records, specifically the Georgia Tech study. And we would also ask that the chair ask Commissioner Irvin whether he has made any final conclusions with respect to what the evidence so far presented in this proceeding shows.
Mr. Chairman, may I respond briefly?
Yes, sir.
Thank you, Mr. Chairman. Council, I've made no final determination about the matter, certainly not. I'm listening carefully and thoughtfully to all the testimony and evidence. Regarding the study, it was your witness that brought it up. Once he brings it up as a fact in the case, I have the right, during commissioner questioning, as you know, to ask him about it. And that's all I was doing. Thank you.
Thank you very much, Commissioner Irvin. If I may, did you review the whole study, or did you review an excerpt of the study?
Would you like to put the study in evidence? Council, would you like to go ahead and put it in evidence?
Commissioner Irvin, respectfully, I believe that the chair has already ruled on that.
Well, you may change his view on it if you just, it might be simpler just to go ahead and put it in evidence for all to see, and we can all draw our own conclusions if you're concerned about it.
Well,
My cross-examination was directly as a result of your witness's testimony. I certainly have a right to ask him about it.
Right. So, Commissioner Irvin, I think I understand where you're coming from, and I can tell that Attorney Knowles is earning his fee today as well by asking you these very difficult questions. So, I'm just going to ask you if you would just answer the question regarding reviewing the Georgia Tech study. I think he asked you whether or not you reviewed the study in whole or in part. Or at all?
Yes, sir. I don't think I have to answer that question, Mr. Chairman. It was proper cross-examination, and I'm not going to, I'm not required to answer that question. It's immaterial because my cross-examination of the witness was proper. He brought it up. I have a right to ask him about it.
Is there anything else from council?
Not from ORS. Thank you, Mr. Chairman.
Attorney Cooper.
If this matter is settled, I have nothing further. I just note that the commissioner is not a witness, so cross-examining a commissioner on what they've read, I mean, they just like asking a question, just like if I pick a statement and read it, Mr. Chairman.
Yeah, I understand. I thought he was going somewhere. Are you finished?
Yes,
No,
Mr.
not you. Attorney Knowles.
Yeah, I am finished. I do not want to take anything any further at this point, and I do appreciate Commissioner Irvin, your time and your responses, and Mr. Chairman, your indulgence.
Okay. So here's the thing. We know this is an adversarial process. It can be a bit intense. These hearings have gotten way more intense than what they once were. So if you have an objection or a motion, it's easier just to state it and lean into it. I appreciate the respect you offered up, but you gotta. I'm telling you what you already know, but I want to put it out there. You have a responsibility to advocate for your client's position. Never be afraid to do that. All right. Is there anything else?
Mr. Chairman, I do have redirect.
All right. Redirect.
Mr. Morgan, let me start. Let me ask you, Ms. Mixon asked you some questions about 583720. Do you recall that colloquy you had with her?
Yes.
Okay. And I believe Mr. Cooper passed out a document that had 583720 on it. Do you have that available to you?
Yes, I do.
Okay. And if you look with me down to the bottom of that section where it says, for the purposes of this section, only the term demand side activity means, and then it has a discussion beyond that. Do you see that portion?
Yes, I do.
And I believe that this question was asked of Mr. Lawyer, but let me ask you, do you see that term used anywhere else in 583720?
No, I do not.
Okay. Let me now direct your attention to the first sentence of that section. And if you'll read along with me, I'll paraphrase a little bit, but it says the PSC may adopt procedures that encourage electrical utilities and public utilities providing gas services subject to the jurisdiction of the Commission to invest in cost-effective energy efficient technologies and energy conservation programs. Do you see that?
Yes.
Okay. Mr. Morgan, let me ask you, do you, in your expert opinion, are the programs that are being proposed by the company in this proceeding, are they cost effective?
Based on the review and analysis of our expert witness, they are not cost effective.
Okay. And do you believe that solar PV is an energy efficient technology?
No, I do not believe that solar PV is an energy efficient technology.
And do you believe that solar PV is an energy conservation program?
No, I don't believe it's an energy conservation program.
Okay. And when you look at the programs, as I understand it, there are different facets of the program, solar PV being one. Are there other components as the program is proposed in Duke's application that are either energy efficiency or demand side management programs?
The company is proposing the solar PV program that is not energy efficiency, and the company is asking or requiring that folks that participate in the program must participate in the BYOT winter program. That is the demand response portion of this, but the program itself is not energy efficiency.
Okay. But is the BYOT program a separate program that has already been approved by this commission?
Yes, it is.
Okay. Mr. Morgan, Ms. Mixon also had some discussion with you about cost shifts related to the HVAC program. Do you recall that?
Yes.
Okay. And do you recall her asking you about energy efficiency programs and if there were cost shifts and if that was appropriate for the HVAC program?
Yes, I recall.
Okay. Are you aware of any statutory limitations on minimizing or eliminating cost shifts on programs such as the HVAC program?
No, I do not.
Okay. What kind of programs do have such statutory limitations?
The Solar Choice program or the Customer Generator program.
Okay. And if you know, can you explain what that limitation is?
Well, based on my understanding, that limitation is the recovery of lost revenue as a result of customers generating their own electricity from PV systems.
Okay, but as it relates to cost shifts, how does cost shifts relate to programs under Act 62?
Well, there is a cost of implementing these programs, and that cost shift is being evident when customers that do not participate in these programs bear some of those costs.
Okay. But or if you are aware, do solar choice programs?
Mr. Chairman, I'm going to object to these line of questions. I let counsel, out of respect for him, continue somewhat, but I established on my questions that this witness has not participated in the solar choice tariff, the solar choice proceedings. He was not in the generic proceeding. He was not in the company solar choice proceedings. He is not an expert on the solar choice statute. And we're getting back into him testifying about his knowledge of the solar choice statute. And I think we've already shown he's not prepared to testify on this. So I object to this line of question.
Mr. Chairman, I'll move on. Mr. Morgan, I want to talk about the collaborative meetings. I know you had several discussions about that. And I wanted to ask you to provide some context for those meetings. I know Mr. Lawyer had some discussion about that, but I wanted to give you that opportunity as well. Can you provide some context as to ORS's role in those collaborative meetings?
ORS's role in those meetings is to, I like to say, have a pulse on the potential or possible programs that will be coming down the line, and to understand how the programs and the discussions that are had in these meetings, how they can benefit the public.
Okay. And Mr. Morgan, do you have, I believe Mr. Cooper had provided Morgan Cross exhibits number 2 and 3, which were minutes from the November 2020 and January 2021 meetings. Do you have those available to you?
Yes, I do.
Okay, and if I can ask you to turn to page 5 of Morgan Cross exhibit number 2. And before I get to that, let me ask you this. When was the first time that ORS was made aware of the Solar as EE program that Duke proposed?
November 2020.
Okay. Had ORS been apprised of this potential offering of the company prior to this November 2020 meeting?
Not to my knowledge.
Okay. And do you recall whether Duke or any of the other parties offered any details regarding this program?
No details.
Okay. Did they provide you with any data or underlying financial information regarding the programs?
No, they did not.
Okay. When was the first time that you were able to receive and review that information, the underlying data and the financial data?
After the company officially applied, we sent out discovery questions to the company, and they did provide those financial statements.
Okay. And do you recall approximately when you received that discovery information?
Not right now.
Okay. But sometime after April 2021, is that correct?
Yes.
Okay. And would that information, or the lack of that information, would that have played into your decision of whether to respond or not in September 2020?
Yes, as Mr. Lawyer says, these are proposals, and we have to wait really to see an official application before we venture down that path.
Okay. And Mr. Morgan, just for clarification, I said September 2020, but I meant November 2020, so I apologize for that. Mr. Morgan, are you aware of Duke having conversations with other members of the collaborative prior to the November 2020 meeting?
No, I'm not aware of that.
Okay. Are you aware of Duke having entered into a memorandum of understanding regarding the Solar EE program?
Mr. Chairman, I'm going to object. I don't know if there's any foundation. I also object on the ground of relevant, that this is relevant. And I'd object that we're getting into hearsay that I don't know this witness is prepared to discuss.
Mr. Chairman, I'm in the attempt of laying a foundation to ask him whether or not he knows. If he doesn't know, then he doesn't. And relevance, I believe, would be borne out if the chairman would give me some leeway. If he doesn't know, then he doesn't know.
Overruled.
All are you aware of Duke Energy entering into a memorandum of understanding with members of the collaborative prior to the November 2020 meeting?
I'm not sure I'm privy to that information.
Fair enough, thank you. Have you reviewed the company's application in this proceeding, Mr. Morgan?
Yes, I did.
And I could provide you a copy with it, but are you aware did Duke include a statement in that application about how it developed the program in this matter?
Yes, they did.
And do you recall what that statement said? If I were
my recollection is, I don't have the application in front of me, but they mentioned that this was a collaboration between, and they list a number of entities or agencies that they collaborated with.
Okay, and was the Office of Regulatory Staff one of those agencies that they collaborated with?
No, they did not.
How many collaborative meetings would you say that you have participated in your time at ORS?
Maybe less than 8.
Okay. And are there any times when a potential program is discussed in a collaboration where it does not result in a filing at the PSC?
I'm sure they have been.
Mr. Morgan, there was also some discussion about whether ORS offered options to the company's program to make those programs more palatable or to satisfy statutory requirements. Do you recall that discussion?
Yes.
Okay. Mr. Morgan, who proposed the programs that are at issue in this proceeding?
The company.
Okay. And based on your understanding, is it ORS's job to rehabilitate programs that do not meet statutory requirements?
No, that's not our job.
Okay. Does ORS look at the programs as they are proposed by the applicants?
Yes, we do.
Okay. There was also some question about did you look at the benefits versus the costs of the programs? Do you recall that discussion?
Yes.
Okay. And did you in fact look at the benefits of the program?
Yes, I did.
Why did you not feel the need to include the benefits in your direct testimony or in your rebuttal testimony?
I believe that the benefits are there, and the company presented those benefits in their proposal and in their testimony. And I wanted to focus on this additional costs that customers will have to bear as a result of these programs.
Okay. Had Duke already outlined those benefits in its application and in its testimony?
In their responses during the discovery process.
Is it ORS's job to make their case for Duke?
No, it's not.
Mr. Morgan, I want to point you now to Section 5840-10, which I believe was a cross-exhibit, beg the chair's indulgence. I believe it was DEC DEP cross-exhibit number 1. Do you have that in front of you?
No, I don't.
Mr. Chair, may I approach the witness just to make sure he's got the right one?
Yes, sir.
Chairman, I apologize. Mr. Chairman, I apologize. I was not aware that I was going to need this. And redirect, I'm looking for a copy of the code section. We have the code book with us. We could put it up if y'all, I guess y'all still have an Elmo, or Ms. Belser has one if you would permit me to approach Commissioner Belser.
I think we all have one. You can take the first one available. Do you need another one? Cross DEC DEP Cross Exhibit 1. Is that what you're referencing, Attorney Mushin?
Yes, Mr. Chair. I wanted to get back to the microphone, but I appreciate that. Yes, and specifically, I'm looking at page 3 of DEC DEP Cross Exhibit number 1.
All right.
Mr. Morgan, do you recall some discussion with Mr. Cooper about customer generators?
Yes, I do.
Okay, and do you recall him talking about exporting of solar generation?
Yes.
Okay. And I want you to look with me at, so this is going to be 584010C. And if you can look down with me as we go, does customer generator include generation that generates or discharges electricity from a renewable energy resource? And then it says including an energy storage device configured to receive electrical charge solely from an on-site renewable energy resource.
Yes, that's number 1.
Okay, and has an electrical generating system with a capacity of, skipping down to B, not more than 20 kilovolts AC if a residential customer is located on a single premises, is interconnected and operates in parallel phase, is intended to primarily offset part or all of the customer generator's own electrical energy requirements, and meets all applicable safety codes. I'm paraphrasing, but you see the portion that I'm talking about.
Yes, I do.
Okay. Let me direct your attention to subsection 3 there. Can you read me that whole subsection?
Is located on a single premises, owned, operated, leased, or otherwise controlled by the customer.
Okay. And can you look at subsection 5 and read that for me?
Is intended to primarily to offset part or all of the customer generator's own electrical energy requirements.
Okay. So is that section only relating to exports, is your understanding?
No, they are not.
Okay. Does that section contemplate, based on its plain language, does it contemplate offsetting of a customer's own energy requirements?
Yes, it does.
Mr. Cooper also talked to you about the interim solar tariff. Do you recall that discussion?
Yes.
And am I correct? Did that tariff become effective June 1 of 2020?
Yes, it did.
Okay. And does the permanent tariff become effective January 1 of 2022?
Yes, it does.
Okay. And you recall the discussion about the rebound effect?
Yes, I did.
Mr. Morgan, when you were looking at this program, did you have any concern with the underlying data related to the interim solar tariff when analyzing whether or not this program was cost effective or would be effective?
Could you repeat the question?
Okay. When you were looking at the proposed programs, and in the context of the interim solar tariff, which became effective June 1 of 2021, did you have any concern with the quality of the data that underlies the programs and their cost effectiveness and their basic effectiveness?
Yes, I did.
Okay. Could you explain for the commission what that concern was?
I had concern in regards to how the data that was, the values that were used to calculate the efficiency cost test were determined. Henceforth, I requested information regarding the details of those values used to determine the cost-effective test values.
Okay. Did you have any concerns with the limited amount of data underlying the interim solar choice tariff?
Yes, I did.
Okay, and could you specifically explain that concern for me?
Well, my concern on the limited amount of data was in regards to how we would analyze if this program would assist with the adoption rate, or is it just a scenario where the company is adding more costs to increase the participation of the BYOT program.
Okay. And do you have a recollection of approximately how many months of data that ORS was provided under the interim solar tariff and how it had performed?
Well, we requested to find out how many applications so far the company had received, and the company presented that information. In their response, they said, I think as of August the 31st, they had received, I think, 545 thereabout. I'd have to check for DEC and around 89 for DEP.
Okay. And did you have any concern with respect to the sample size, if you were, about estimating the effectiveness of the program?
Mr. Chairman, I'm going to object. I've let counsel go for a while with leading questions. It is his witness. I tried to help us through the expediency of not interrupting him, but he can ask what problems, and the witness can answer it, but he doesn't get to lead his own witness.
Mr. Chairman, that suggests a response. My question was, did it give you concerns? He can say yes or no. It's not suggesting what the answer should be. Did you have concerns such as X, Y, and Z? I'm only asking him the very direct question of, did he have concerns? If he didn't, he did.
I understand the objection is overruled, but please just focus on the open-ended questions, please, sir.
Yes, thank you, Mr. Chairman. I'll repeat the question. Did the sample size of the information that was provided by Duke, did that give you concern about your ability to analyze the program?
Yes, it did.
Okay, and could you explain that for me, please?
My concern was the company estimated that over 5 years they are looking to see a participation amount of, I think, 3,116 for DEC, and the sample size that I received was trending in that direction without the program incentive, so I had concern about that.
Mr. Morgan, do you recall the discussion about the true-up of the program?
Yes, I do.
Okay. Mr. Morgan, in your expert opinion, with your experience in education and energy efficiency and DSM programs, do you believe it would be appropriate to approve a program that may or may not have benefits only because it would be trued up?
I do not approve of that.
Okay. Has Duke provided ORS with any information about how such a true-up would occur?
Well, under under the energy efficiency EEDSM recovery mechanism, that's how they propose they would gather all those costs.
What would happen with the incentive? Has Duke explained what would happen with the incentive that they had already paid out to customers if the program was ultimately determined to be not a good program?
No, I'm not aware of a program to give back South Carolina residents money that they have paid as a result of these programs.
Mr. Morgan, is your concern let me rephrase. Mr. Morgan, do you have a concern with the company recovering lost revenue for these proposed programs?
For this program in particular, yes, I do.
Okay. Do you have a concern with the company recovering the program performance incentive as proposed?
Yes, I do.
Do you have a concern if Duke did not seek to recover the lost revenues and did not seek to recover the PPI? Would you have a problem with Duke proposing and offering incentives for solar PV?
First and foremost, yes, I would, because solar PV under the proposal being classified as EE, I have a concern with that. If it's a separate program, that's another question I'll ask. Is it lawful to recover these programs given Act costs, given Act 62?
Okay, but if it were not EE, if they did not seek lost revenues and if they did not seek PPI, would you have a concern with Duke implementing a program of providing incentives for solar customers?
I would have to think about that, because I thought we have already provided all the benefits in terms of incentives to solar PV customers in the solar choice tariff. So I would have a concern.
Okay. Well, Mr. Morgan, let me just ask you one last question. If solar PV is classified as energy efficiency, what would the cost impact of that be in a broad sense? How would customers be impacted by solar PV being classified as EE? Not just on this program, but in general.
Well, if we're not looking at this program in particular, I'm looking at the long-standing industry definition of solar PV being classified as EE, and that would disrupt the market negatively, as I think it may go down a slippery slope where someone could potentially put the best efficient generator at their premises, and since they're not using the energy from the grid per se, this could be classified as an efficiency measure.
But if solar PV is classified as EE, I guess specifically, how would or would that impact the EEDSM rider that is ultimately charged to customers?
Well, all the costs that are recoverable under the EE programs, the costs are calculated and they are reflected in the rate riders, and customers, all residential customers, would be impacted by those costs being in the rate rider.
Thank you, Mr. Chairman. That's all I have.
Mr.
All
Chairman,
right.
at this point, would you have ORS do redirect of Mr. Lawyer, or would you have Mr. Cooper proceed with recross?
You have recross for Mr. Morgan?
Mr. Chairman, I do.
All right, let's knock that out, then we go to Mr. Lawyer.
Thank you very much, Mr. Morgan. You were asked a question about your concerns about the cost effectiveness of the program on redirect. You just so I'm clear, you did not make any independent calculations yourself. You said you're correct?
Yes, we employed an expert witness to help us with that analysis.
Okay. And you mentioned that you have you had concerns about the adoption rate of the program. That was one of your concerns with this program, correct?
Yes,
And isn't it true anytime there's a new program that's never been implemented before, the adoption rate is somewhat, it's got to be based on study, it's got to be based on estimates, somewhat hypothetical. It's an educated guess. Is that right?
yes, it's not, I mean, forecasting is a science.
But
You know,
But it's just that it's a forecast. Is that correct?
yes,
And so with any energy efficiency program that is put forward for the first time before this commission for adoption, you're going to deal with forecasts.
yes,
And that would be true for benefits as well. Those are forecasts.
yes,
And it's true that that's why we have this ability to come in after it's effective and review it, these forecasts, and we can review the adoption rates, correct?
yes, but
Sorry, please finish.
But with the data that was presented to us, it shows that customers are willing to make that decision to go to solar PV systems without additional incentives with the limited data that we receive, of course, but the company did not provide any additional data to support their position that these incentives are necessary to continue the adoption rate.
And when you say continue the adoption rate, you recall earlier I asked you questions about the interim tariff that's currently in effect, correct?
Yes,
And so when we talk about continuing adoption rates, we're talking about adoption rates that are in place, correct, right now that would reflect the interim tariff, correct?
I agree cautiously.
Thank you, Mr. Morgan. So when we talk about adoption rates going forward, we're talking about a program that in January 1 will have a minimum bill, we'll have mandatory time of use rates, we'll have mandatory critical peak pricing, in other such additional charges that's not in the current interim program. We talked through that. Is that correct?
That is correct.
Okay, thank you. So applying the adoption rates to the current interim program is really, you know, there's a limit to applying that to this new program that will go in effect January 1 that has these additional rate features, correct?
That's, one may gain that opinion, but where I'm looking, I see that the customers are making the determination to go to become solar PV generators without any additional financial assistance, whether customer incentives or company incentives.
Okay, thank you. I want to turn now, Mr. Morgan, sorry. I want to ask you were asked a line of questions about the plain language of Act 62 and the recovery of lost revenue. And I think you were also asked about Section 583020, which is the EE statute. Do you have 583720 in front of you again, still?
Yes, I do.
Okay. Thank you, Mr. Morgan. The second sentence says, if adopted, these procedures must, and if you keep looking down, 2 lines down, it says, let me just read you the whole thing for simplicity. If adopted, these procedures must provide incentives and cost recovery for energy suppliers and distributors who invest in energy supply and in-use technologies that are cost-effective, environmentally acceptable, and reduce energy consumption or demand. Allow energy suppliers and distributors to recover cost, and this is what I want you to really listen to, please, sir. Obtain a reasonable rate of return on their investment in the qualified demand. And then it goes on to say, demand-side management programs sufficient to make these programs at least as financially attractive as construction of new generating facilities require the Public Service Commission to establish rates and charges that ensure that the net income of an electrical or gas utility regulated by the Commission after implementation of the specific cost-effective energy conservation measure is at least as high as the net income it would have been. So would you agree with me that what I just read, it's focused on net income to the utility?
Again, I would like to to state what was stated before in regards to looking at this section of the law in a vacuum without considering, another section 584020. I think that's a wrong approach, because there is a date given on 584020 that says after this date, and it's the same set of customers that section 584020 that is saying those lost revenues should not be recovered by the utility company. So putting them, separating both of these, I think it's a wrong thing to do. That's my expert opinion, looking at the totality of the laws in front of us.
Okay, thank you, Mr. Morgan. And I understand that's your testimony. I didn't want to interrupt you, but I'd ask, just as I let you answer completely, but I do ask that you answer my question. And my question was very specific. My question is, the section I just read to you, is it correct that it focuses on, quote, the net income of an electrical or gas utility?
Yes, that's the statement.
Okay, so we agree that that focuses on net income. And as you said, you wanted to read these together, so I'm going to do that. I'm going to now turn to 584020 I. So that's the, I hope, Mr. Morgan, do you have that handy still?
Yes.
Okay.
I can find it.
So with that, I want to read this to you. First of all, would you agree with me that says electrical, the last sentence that you've been focused on, it says electrical utilities are prohibited from recovering lost revenues, correct?
Yes.
And so lost revenues are not the same thing as income, correct?
Objection, Mr. Chairman. I think that calls for a legal conclusion.
State the question again.
Mr. Morgan, I asked Mr. Morgan, I'll restate the question, I'm sorry. Under 584020 I, it states that electrical utilities are prohibited from recovering lost revenues. Is that correct?
Yes, that's the statement.
And my question was, Mr. Chairman, lost revenues are not the same thing as net income.
Mr. Chairman, same objection.
Are you asking him based on that statute?
Well, I'm asking because he said that in his answers to redirect, he said because of this prohibition in the solar choice statute on the prohibition on recovery of lost revenue, that that the company's prohibited from recovering income under the EE statute. That was his plain testimony. And so I'm just trying to ask him questions when he says that these are different terms.
Mr. Chairman,
I
respectfully,
understand. Attorney Mushin, my folks in the back are asking me to ask you to sit in Mr. Knowles' chair, or sit where Mr. Knowles is sitting now.
I apologize, Mr. Chairman.
No problem. So I understand what Attorney Cooper is saying. I do remember him making that statement in redirect. So what's your response?
Mr. Chairman, I believe there's a difference between his opinion as an EEDSM expert and when he's analyzing these programs, as opposed to asking him to interpret what one statute means in the context of another. And that's what I understand Mr. Cooper to be asking him, which is lost revenue that is discussed in 584020I the same thing as net income that is in 583720? And in my mind, those are that is asking for a legal conclusion as opposed to his view of when he's reviewing the programs.
Mr. Chairman.
Yeah, I think he can answer the question. If he can answer it, I don't think it's all out of bounds.
Okay, thank you, Mr. Chairman.
Objection overruled.
Could you repeat the question?
So, yes, Mr. Morgan, the concept of recovery under the EE statute, when a utility comes to recover under the EE statute, it's recovering net income. When they seek to recover under the Solar Choice program, they'll be seeking to recover lost revenues. Those are very different concepts, correct?
I can admit that how the mechanism that exists works is somewhat different in how these lost revenues are calculated, but lost revenues are lost revenues. If the company, as a result of these programs, are selling less energy, less electricity, they're now trying to claim those savings and bundle under the portfolio of the energy efficiency program to determine that net income. So those numbers are coming from the same customers. So I mean, we're playing on the wording, but it's still lost revenue used to calculate on either side.
Okay, so Mr. Morgan, I want to play your logic out for the commission. And you said we should read everything together. So your statement was because Act 62 had this prohibition on lost revenues, that because that was in the solar choice section, that applies to the EE section. Fair statement?
Again, because I'm not seeing the solar PV as an EE measure, I'm trying to grasp my head around the concept. But it is, again, it is the same set of customers that the company will be using those numbers to calculate the net income or the lost revenue. So you ask for my interpretation, I see it the same.
Okay, so let's go back, and I want to read you the full statement out of the solar choice. It says, nothing in this section, however, prohibits an electrical utility from continuing to recover distributed energy resource program costs in the manner and amount approved by the Commission, order number 2015-194 for customer generators applying before June 1, 2021. Such recovery shall be in place until full cost recovery is realized. Are you aware of that statement that appears? Those are the two sentences appear after the sentence we've been discussing.
Yes, I'm aware of that statement, and that statement is simply saying those that have been participating in the previous NEM programs, the company can continue to collect those lost revenues until they are fully collected. But for any new, it continues, but for any new customer generators, they are prohibited from collecting lost revenues from those. And the program presented the customers that will be able to participate in the program will have to go through the solar choice.
Right.
So it's the same, taking the savings. You can take the savings there to calculate your lost revenue. You can now take the savings here since it's under a new program. You can take the savings here to calculate that net loss revenue. I think based on my reading of the law, and you ask again for my expert opinion, I think that it's not in line with the law to do so.
Okay, thank you.
That's my opinion.
Thank you, Mr. Morgan. So I have actually a very limited question that it's focused and I'm trying to talk through. But given that it's expressly approved for these prior programs, right? So exactly what you said. So I'm talking about the Act 236, only Act 236. I'm not talking about solar choice.
Okay.
Given the fact that the law specifically allows the company to recover lost revenues in connection with that program, as you just explained. By your logic, the company is allowed for those programs to go under any other mechanism. They could go under any other thing under the statute and come in before this commission and say, we're allowed to recover lost revenues. Because it allows us to recover lost revenues for this DEM program under Act 236. So guess what? We have a completely unrelated program. The law doesn't provide for the recovery of revenue in that program, but we get to come in and recover lost revenue for that program because it says it here under Act 236, so we get to apply that across the board under all statutes. Isn't that correct?
Mr. Chairman, couple things. One, I believe that is a multifarious question that has multiple components. If he has a question, then I would ask him to ask it directly and succinctly. That would
Sustain. What's your next one?
I also believe that he is testifying as opposed to asking questions.
Sustain. What's the next one?
And I also believe that we have gotten far afield from what I raised on redirect, which I never talked about, order number 215-194. In fact, Mr. Cooper was very specific that and objected to one of my questions that Mr. Morgan was not involved in the solar choice tariff, and now he is specifically going down a line of questioning that's already been addressed.
I'm inclined to sustain that one too.
I had a feeling, and I'm going to say guilty for the first two, but on the last one, Mr. Chairman, I think the difference is, I would say respectfully, Mr. Morgan testified completely about how this bar that he sees, this bar under Act 62, is a bar for any other program. And all I'm trying to do to bring to light to the commission is to show that what the flip of that logic would be, which would be that, Mr. Chairman, I'm allowed to answer the chairman's question.
But, Mr. Chairman, Mr. Cooper is now testifying as to what his intent in asking these questions is. This goes beyond, you've already ruled on the objection, you've sustained the objection, and he is continuing to argue, which is improper under the rules, and he has just admitted that this line of questioning is not intended to elicit a response, but intended to indicate to the commission what his concern is.
Mr. Chairman, with all due respect, you specifically...
Let's slow down a little bit. So I sustained the first two objections.
Thank you.
I'm asking for clarification on the last one. And he was responding to that clarification. Are you finished?
If I may, just to try to clarify it, so I'm allowed to ask the witness questions, and I'm allowed to cross the witness. And I'm sorry if these are difficult topics, but the witness provided statements regarding the full context and the full scope of, in his opinion, the prohibition on recovery of net loss revenues. I'm entitled to ask this witness, his understanding and his position on the scope of the allowance of recovery of revenues on the very same section of the statute to which he's testified.
Okay.
Mr. Chairman, just respectfully and briefly, in my my redirect of Mr. Morgan, I asked about the cost shift. I did not ask about the recovery of lost revenues. That was an issue that Mr. Cooper fully addressed on his original cross. I did not bring this issue up on redirect.
Mr. Chairman, there was a question about HVAC and limiting cost shift only to solar choice, to which this witness said, because there's a restriction for solar choice, it applies to energy efficiency. I'm just trying to follow up on that.
All right. Well, I'm sure you're getting close to finishing up, so we'll let it in for whatever's worth.
Thank you. So, Mr. Morgan, you've stated that the prohibition in Act 62 on the recovery of lost revenue for customer generator programs applies to the EE statute as well, correct?
If the measure that the EE program entails customer generator programs, it is my opinion that those costs are not recoverable.
Okay. Therefore, if Act 62, immediately above that sentence, if Act 62 affirmatively permits the recovery of lost revenue, then you would similarly agree that that allows the company to recover lost revenues across the board into other areas that may not allow the recovery, may not expressly allow for the recovery of lost revenues. Correct?
Repeat your statement.
If if Act 62 affirmatively provides the right to recover lost revenue for net energy metering under Act 236, if that's an express allowance, then that therefore is allowed for any other program, whether that program allows for recovery of lost revenue or not, because there's that one statement in Act 62, correct?
I think you are simplifying my statement, but I am not too clear on the question that you're asking. So I cannot provide a yes or no answer.
Okay. All right, so let me start over then. The statute, Act 62, do you see where it says, nothing in this section, however, prohibits an electrical utility from continuing to recover distributed energy resource program costs in the manner and amount approved by the Commission for customer generators applying before June 1, 2021.
Yes, I see the statement.
And that is an affirmative statement that there's an allowance for recovery of costs, correct?
Yes, continued recovery of costs for existing.
Okay. So because there's that express statement for existing customers, the company, by your logic, can recover costs for other programs that only these existing NEM customers, but these existing NEM customers could apply for, whether that program allows for cost recovery or not.
That's not what I'm saying.
Okay. Okay, thank you. But all right, I think we're clear on the two readings. finally, you mentioned that you did not discuss the benefits because the companies have, they discussed the benefits. Is that correct?
Yes, they provided the benefits.
So therefore, you don't have, in your testimony, then you don't have any, you don't discuss an alternative calculation of benefits, correct?
No, I did not.
Okay. I don't have anything further. Thank you very much, Mr. Morgan.
Thank you.
That was recross, correct?
Commissioner, that was just recross of
Mr.
witness
Morgan.
And so
And
now I
so
believe,
there's redirect
Yeah.
from Mr. Knowles of Mr. Lawyer. Is that correct? Is that where we are? Yes. See, I am paying attention.
Okay, good afternoon, Mr. Lawyer. I'm going to try to just talk to you about two subjects. First thing I want to talk with you about relates to the collaborative. In your experience, how does the collaborative and related process work?
I think it has its ups and downs. Excuse me, can you hear me good? I think it has its ups and downs, just like any other meetings you would have with a whole bevy of different groups with different interests in mind and at heart. For the most part, overall, I think it's good.
Are there ever any confidential discussions during these collaborative meetings?
I don't know if they're actually labeled confidential. I will say this in the spirit of a collaborative, and not only this one, we're involved in, gosh, probably 18 other ones at ORS. I think 9 of them are with Duke alone in all different areas. But usually it's what happens in the collaborative happens in the collaborative type of atmosphere. Most of their slides are say this is for discussion purposes only. Do not disseminate to other parties without written consent from Duke. That's my understanding. It doesn't specifically say confidential, but I think there's an unwritten rule, the gentleman or gentlewoman's code of conduct when it comes to the collaborative.
Mr. Lawyer, and could you just describe what you view as ORS's role in the collaborative?
Mr. Chairman, I'm going to object. I've been reluctant to object, but there's a limited scope for redirect, and it has to do with the commissioner's questions and clarifying something that occurred during the commissioner's question. This is just getting into testimony that Mr. Lawyer has already provided, and this is just, a broad second chance at broad testimony.
Mr. Chairman, my understanding was that redirect is proper to respond as well to cross-examination from the parties, and I do not intend to belabor this point.
I think you're both right. We asked questions about the collaborative. Proceed. Objection overruled.
So, Mr. Lawyer, would you please describe your understanding of ORS's role in the collaborative?
Sure, and I think I stated it earlier. We're there to gather information, monitor, see what may be coming down the road or what people are thinking about doing, whether it's new programs or improving existing programs, tweaking something here and there to make it better. Our role, again, is not to help design or develop the programs in the collaborative.
Mr. Lawyer, how do you think that the functionality of the collaborative process would be affected if every proposal put before a collaborative were subject to the kind of in-depth vetting that we're seeing in connection with this proceeding?
You probably would probably never get anything done or finally proposed.
Let's see. And Mr. Lawyer, when was the first time, as far as you're aware, that ORS first saw the details of the proposed program that's now before the commission?
Well, I don't know what you mean by details. I can tell you it was first mentioned, I think, back in that November meeting and then the January. We didn't get any real details until, we performed discovery.
Mr. Lawyer, are you aware of Duke having conversations with other members of the collaborative before November 2020 related to the proposed program?
Mr. Chairman, I'd object. This witness already stated that they did not participate in the collaborative and did not attend any of the meetings, if I'm correct.
I don't remember him saying that. Do you have a response?
I personally did not remember him saying that either. I'm not saying that he didn't, but I would say that if,
Don't worry about it. Objection overruled. Please proceed.
Thank you. All right, so yeah, Mr. Lawyer, are you aware of Duke having conversations with other members of the collaborative before November 2020?
In relation to this proposed program?
In relation to the proposed program, yes, sir.
I don't know if it was before that specific date, but I thought I heard testimony about the 36-cent incentive. People meeting about that outside of the collaborative,
Okay.
if I'm not mistaken. So
Mr.
no, we weren't a part of that, but we were part of the regular collaboratives. We were not part of that piece.
Thank you. And so with respect to the incentive part of the proposed program, do you understand that Duke and other members of the collaborative had reached an agreement relating to the proposed program now before the commission?
Yes, that was my understanding.
Okay. And that agreement was reached in September 2020?
Subject to Jack, I'll agree with that.
Mr. Chairman, I realize I've lost everyone, but this is leading. He can ask the date.
Please ask open-ended questions, please. Sustain.
Thank you, Mr. Chairman. Mr. Lawyer, are you familiar with the, well, let's see. When do you understand that Duke and the other members of the collaborative reached an agreement on the proposed program?
On the proposed program or the incentive piece?
The incentive.
If I remember correctly, that was part of the MOU and the solar choice docket. Is when I first heard about it.
Okay. And are you familiar with that MOU?
Yes.
Okay. I am going to send out ORS Cross Exhibit 10. Okay, Mr. Lawyer, does this appear to be the MOU that we were discussing?
It does appear to be that.
Okay, and who are the parties to the MOU?
Let's see. Duke Energy Carolinas, Duke Energy Progress, North Carolina Sustainable Energy Association, Southern Environmental Law Center on behalf of South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Upstate Forever, Sunrun Inc., and Volt Solar.
Okay, and what's the effective date of the MOU?
September 16th of 2020.
Okay. Under the non-binding understandings, you see subparagraphs 1 and 2.
I do.
Mr. Chairman, I'd object. I think that ORS should lay more of a foundation about this witness's knowledge of the MOU before questioning this witness on the MOU. I mean, this is just a way of saying, hey, read this into the record. And I think there's not a foundation, I think, that Mr. Lawyer testified earlier that he was aware of.
I'll
Mr.
say,
Knowles?
yes, sir. For one, this is a document that has been executed by Duke. It's a document that Mr. Lawyer has said that he's reviewed and that he's seen it before, and it's the document that he says it was. So I don't think there's any real question that this document is what it purports to be.
Okay, anything else?
Mr. Chairman, I think this also goes to that he needs to establish that this witness is aware of this document, that this witness is competent to testify on the details of this document, and I don't think that ORS has done that.
All right, lay a bit more of a foundation for this witness's knowledge of this document, and please proceed.
Okay. Mr. Lawyer, you were involved in the Solar Choice dockets.
That's correct.
Did you see this memorandum of understanding filed in the Solar Choice dockets?
Yes, I did.
Okay. And I mean, have you reviewed this document in the past?
Yes, I have in the past.
Okay. So you went through its contents and familiarized yourself with them.
Yes.
Okay. So I think with that, Mr. Chairman, I would ask that this be entered into the record as the next hearing exhibit.
ORS Cross Exhibit number 10 will be marked and entered into the record as hearing exhibit number 7.
Okay, and just in the interest of time, to try to speed things up, on the first page, you see paragraphs 1 and 2 discussing that the companies would propose the interim solar choice tariffs on the terms and conditions in Exhibit A, and you see that the companies would propose permanent solar choice tariffs upon the terms and conditions on Exhibit B. Is that right, Mr. Lawyer?
That is correct.
Okay, and then turning to the next page, paragraph 3, the companies would propose the incentives in conjunction with the permanent solar choice tariffs to the PSC and NCUC upon the terms and conditions on Exhibit C. Is that right?
Yes, that's correct.
Okay, looking at Exhibit C, which is just 3 pages from the very end of the document, if I'm not mistaken. Mr. Lawyer, if you wouldn't mind, just take a minute and look at Exhibit C.
Okay.
Mr. Lawyer, do you see a great deal of overlap between what's laid out in Exhibit C and the programs that have ultimately been proposed to the Commission for consideration in these dockets?
Yes.
Okay. And turning to the next page, that's 16 of 18, that paragraph at the end, the parties would vigorously advocate in North Carolina and South Carolina for approval of the incentives described above, as well as full loss revenue recovery and shared savings incentives. Is that right?
Correct.
Okay.
That's what it says.
Okay. And this was executed before ORS had learned of the proposed programs or the proposed incentive. Is that right?
Correct.
Okay. All right, thank you. That's all that I have on that one. Mr. Lawyer, I do want to talk with you quickly about, talked about some cost effectiveness test results in EM and MV. Let's see. Which ORS witness performed ORS's cost effectiveness review in this docket?
That would be witness Ori.
Okay. On EM and V, when is EM and V performed on an EEDSM program?
In respects to this case, I think the company said they were going to do it in about a year after participation started, so I would assume beginning of, 2023, they would initiate that.
So EM and V is performed on approved programs?
Yes.
Okay. And approved programs, there's a variety of cost effectiveness criteria that they have to satisfy to be approved, right?
Correct.
Okay. What information has Duke provided to ORS about how the EM&V true-up will work?
Nothing that I'm aware of out of the ordinary. No details about how it would be conducted. I just assumed it would go like normal EM&V did after a year of participation.
Okay.
No further details were offered.
Thank you. Okay. Thank you, Mr. Lawyer.
Is there any recross?
Mr. Chairman, we don't have any recalls at this time. Thank you.
Okay. So I can excuse these witnesses. I think they're finished. Right? No further questions. All right, witnesses, you may step down. You're excused. We're going to adjourn for the day. We'll be back. Or excuse me, we're in recess. We'll be back 12:30 tomorrow. All right. All right. Thank you very much.